Hello, everyone, and welcome to this session on Section 11 and the appointment of an arbitral tribunal. This session is hosted by Economic Laws Practice. Without much ado, I'll start with introducing our speakers. First, we have Justice B.N. Sri Krishna. I don't think Justice Sri Krishna needs any introduction. He is one of the foremost names in arbitration in India and is actively working towards changing the arbitration landscape. After his tenure at the Supreme Court of India, he has been part of numerous committees, and we thank you for all your efforts, sir. Moving on, I would like to introduce Mr. Manish Lamba, who brings with him not only his experience as an arbitrator, but also extensive in-house experience, including at big corporate giants like Bharti Airtel and DLF. It would be very, very, I think, helpful to have your insights on this topic as well, Mr. Lamba. Moving on, I'd like to welcome Mr. Nicholas Peacock, who has over 20 years of arbitration experience and has sat both as an arbitrator and access counsel to parties, and brings a very diverse international perspective to this discussion. Mr. Peacock has worked both with Singapore and UK law. So welcome, sir. And I would like to introduce Mr. Naresh Thakkar, who has over 20 years of experience in the world of international and domestic arbitration in India, and leads the arbitration practice at Economic Laws Practice. Thank you. Before we start the session, I would just like to point out that this session is being transcribed. And over to you, over to the panel.
Thank you so much, Shreya, for that wonderful introduction, and a very good morning, good afternoon, or good evening to all of you, wherever you may be joining us from. Welcome to this first ever India ADR week launched by MCIA, and to this session, which is being hosted by ELP, which is titled Section 11, and the appointment of an arbitral tribunal, a true prologue. Now, I'm quite certain that each one of you has joined us this afternoon for the stellar starcast that we have managed to assemble on this panel, and not because of our choice of topic. And I admit that I am guilty as charged. And this topic is as mundane can be. And I won't fault you for asking if this yet is a topic requiring an hour's discussion. Well, if you ask me, as it turns out, in India, it yet merits just as much footage as an old Bollywood biopic that almost all of us relate to did in the heydays of the 70 reel. And I'm sure you know what I'm talking about. But on a serious note, when I opened the Sunday newspaper, the first article that my eyes fell on was one where the law minister, when he was addressing a gathering organized by the Bennett University's School of Law, said, and I quote him, that India has the potential to emerge as global hub of arbitration. And he mentioned international arbitration. Now, I absolutely do not doubt this statement, because we are second to none when it comes to expertise and application of mind. And to me, it is truly the execution where we have always floundered, always. And let me ask this question: for how much long are we going to dwell on the potential that India has? Have we not been doing just this, if not earlier, since at least 2012, when the Supreme Court pronounced its decision on Balco? That, for many and for me as well, was a turning point in the law on arbitration in the country. But what next? And that is the question that everyone asks in this country. The law on arbitration in India prior to 2015 has moved one step forward and two steps backwards, and all of us know it. Come 2015, we saw a different trend. It now moves one step forward and one step back. Now, because we remain in a constant state of motion, we believe that we are moving forward. What we possibly do not realize, and this is to our own detriment, is that while we continue our motion in circles, the world is actually passing us by. And this is a sorry state of affairs that even in 2021, we yet just speak of our potential. And this is one of the reasons for the choice of this topic, a topic so mundane that it does not deserve a second glance. And yet in India, we struggle to tame this unruly horse, fondly referred to as Section 11. Now, without wasting any further of my breath on this subject and your time and the time of this panel, and also trying to decipher the nuances of the topic on my own, let me quickly turn the heat on the panel. My first question, sir, is for you, Justice Sri Krishna. And before I ask this question, sir, I would actually want to give a small preface. Though my question is very simple, but I do believe that it would yet require a preface. Section 11 saga truly began with Sundaram Finance. It trickled down to Konkan Railway Corporation, then was finally settled by SBP and Patel Engineering, albeit to my mind somewhat incorrectly, where the Supreme Court gave unto themselves and every other court in this country appointing arbitrators expansive powers of scrutiny, even before such appointment could ever be made. And they allowed the courts to enter into what I believe is the arbitrator's domain, such as questions of existence of dispute, validity of an arbitration agreement, whether dispute is time barred, and so on and so forth. Then, sir, came Bogara Polyfab, which narrowed down the expanse a little. And then, sir, you authored Shin-Etsu Chemicals, which, according to me, laid down the correct test, that of prima facie scrutiny. And, sir, mistake me not, I'm not saying this just because you are on this panel. In fact, the 246th Law Commission, headed by Justice A.P. Shah, actually wholeheartedly advocated your view. And sir, 2015 amendment unfortunately did not accept all the recommendations of the 246th Law Commission, yet there was an important outcome, and that was an introduction of Section 11(6)(a), whereunder the scrutiny of the courts were to be limited to the existence of the arbitration agreement. Things did improve post 2015 for a bit, but then, sir, we had three successive quick decisions that went the other way, and then came Vidya Drolia. Well, sir, what can I say? A decision which, to my mind at least, does open up old wounds when it requires the court to do, and again, sir, I quote the court, to do an intense and yet summary prima facie review. So I have not understood this phraseology, but it says intense and yet summary prima facie review of the arbitration agreement, and then further says that the existence and validity of arbitration agreement is intertwined. Fortunately, sir, this decision is now before the larger bench of the Supreme Court in NN Global and NN Global Mercantile. My question to you, sir, is what next? Where are we headed on this journey, and why is this one innocuous provision so troublesome for the judges? So the lawyers obviously want to make money out of it, and it's all very good for the lawyers. But why would the judges allow this to continue, sir?
Right. Thank you for the preface, which was very much needed. Naresh, what has happened is this. Arbitration was supposed to be an informal mechanism of resolving a dispute, as opposed to the formal mechanism which the state had by way of the judiciary. All that he needed was a person with robust common sense and unimpeachable integrity as an arbitrator, nothing beyond that. That would suffice. But nonetheless, as a famous Chief Justice in England said, a smattering of law also helps. Now what has happened is, Section 11 did what? Section 11 says, if you have an arbitration agreement and you can't agree on the arbitrator or the arbitral tribunal, then you have to naturally go to a third party, and they said, all right, let the Chief Justice recommend, put his name and finish the matter. There was also a provision right from the beginning, if you have noticed, that the Chief Justice or his nominee or the institution to which he may recommend. Now, if the institution was already there, look what would have happened. Let's say MCA was the institution that was recognized. Now, you would not come to Chief Justice at all. You are supposing A and B have a dispute about whether an arbitral tribunal should be X or Y. They would go straight to the MCA or whatever the institution and say, please nominate. They would find out somebody and nominate him and fill the matter. Now, at the time of nomination, they are not going to think whether this is an administrative order or it's a judicial order. If it is administrative order, is it liable to be challenged in Article 226, whether I am state or not? Nothing of the sort. They want the matter to go proceed. Now, if you have a judge in position to decide this, all these complications. So first he will say, what do you want to find out? Existence. Now, even the word existence I don't like. Is there an arbitration agreement? Somebody comes and says, I'm I want to arbitrate. The first question you ask is, do you have an agreement with an arbitration clause? Yes, show it to me. That's it. Then go ahead. Whatever you want to say, arbitration clause is bad, no arbitration, not liable to be arbitrated, blah, blah, blah. Go and blast the arbitral tribunal number with, he will take care of it. Why on earth should I poke my nose into it and say all kinds of things which have landed us from 2 judges to 5 judges to 7 judges, and then again 2 judges, and then again 5 judges, and then God knows where we are going to land up. This is a mess. I'm sorry, I'm using a very derogatory word. This is a mess that is created by, it's a self-created mess, the judges themselves. If they've just let and said, no, an ordinary man, if you talk of him and say, is there an arbitration agreement? He'll say, show me the agreement. And say, yes, it is there or not. He will not say whether it exists, whether it has legal existence or not. Why do you want to all this hair splitting? That is all that was necessary. Rest of it was all the tribunal would have taken care of it. Now, why is it so? You ask me a very relevant question. Because I am a judge, I want to exercise power. I have a danda, Nick, for your benefit, danda is a stick in my hand. I have a danda in my hand, so I must beat somebody who comes to me. That's all. That is the only reason why they intervened. Simple thing was, no, otherwise, no, see what is going to happen. If you say legal existence, question arises. Somebody may say, this is not my signature at all. This is gold. Or I've been at the end of a gun, I've been asked to sign it. Or I was given too many shots of whiskey and I was to sign it. Or I was under the influence of drug and I signed it. Or I was a minor when I signed it. Who's going to determine all this? The judge is going to determine all this. Then where is the arbitration? Arbitration is 100 miles away and maybe 10 years away. This was not the intention. Now all this can be conveniently raised before the tribunal. The tribunal will answer every one of them. Then once for all. Then make it appealable and the appeal judge will take care of any legal issue that are there. This was the simple thing. We complicated it. And after all, what did Section 5 say? Section 5 clearly said that you shall interfere unless it is actually required under the law. Which law required you to interfere under Section 11? Which provision of the Arbitration Act even today requires you to interfere under Section 11? Nothing except the judge-made law for their own benefit. That's all that I would say.
Thank you so much, sir. And I wholeheartedly agree with what you are saying, sir. And in fact, if one was to turn to Section 5, and if the judges were to even spend 2 seconds looking at Section 5, it makes it very, very clear that there is no interference required by the courts in the arbitral process at all. And I don't understand, sir, how better can the law say this when it says what it says in Section 5? Then Section 19 will say that you don't need evidence, you don't need CPC. The courts have time and again kept on saying that there is the least interference is the best insofar as arbitration is concerned, and yet continue to have the sort of interference from the court that we see. Now, my second question is actually to Manish. Manish, as an arbitration user, because that is, and I would truly say that this is a service which is being provided. We are living in times when lawyers provide services, so also the courts are actually providing a sort of a service. The arbitrators are providing a service. As an user, what do you think is the quickest path to appointment? Would you call it? Would you say institutional arbitration, or would you say ad hoc arbitration? And according to you, why? And if you can also tell us the pitfalls of both, or either, if you want to tell us about it.
Thanks, Naresh. See, the quickest, the fastest way is institutional in the present framework. If the institution was to appoint, the question whether it is a administrative order or it is a judicial order comes to an end. That is not required at all. And but now for whatever reason, we'll have to live in the realism. In India, it is sometimes not, parties are not agree to agree on an institution. And that is how we have so much of ad hoc arbitration. If that be the case, or let us take, for instance, under the various statutory arbitrations where the arbitrator is required to be appointed by a body and things of that nature, I personally feel that we have not used technology enough. A very simple answer. Now, if you look at all the judgments which are there, and if you look at them, how did they translate into the practicality? Whether you look at it, whether it is an administrative order or it is a judicial order, at the end, we have 50 pages of sermon, 25 judgments quoted, everything said, and ultimately the end result is the same. A person gets appointed as an arbitrator. Now, all that 50 pages and 200 pages of a section 11 petition is not required, while all that what is required is you need to show that there is an arbitration agreement and arbitrator needs to be appointed. The entire prima facie case or the entire case is reproduced insofar as those matters are concerned. And I believe that it is very difficult for the judges to come to a conclusion that they've been asked to perform 90% of the job is administrative in nature. Now, this seems to be very derogatory, and it has to be, if a judge needs to decide an administrative job also, he needs to do it judiciously. And then the entire trouble comes into being. I have examined many orders which have been passed in the last 1 year. Delhi High Court would have appointed near around about 800 applications would have been dealt with. Supreme Court would have dealt with around about 60 years. 1 year preceding this year, this figure would also have been in the same vicinity, if you go by the diary number which is available in the cause list. Out of that, 99% of the cases, no qualification has been provided. And in 90% cases, there is no dispute also whether or not the arbitrator needs to be appointed or not appointed. It's a simple name needs to be given. If this entire process is put into an IA, both the parties, if they were to register their on a platform, if they were to register their existence of an agreement, and all that what was required was that they say that we need to push a button and say that a dispute has arisen under the agreement and arbitrator needs to be appointed. All that the IA would do is in 45 seconds, they would come up with a name. If you have a dispute with respect to the same, you can move to the court. Otherwise, 99% of the cases would get sorted out. So I think it is not only getting to the debate with respect to whether it is an administrative or it is a judicial order or things of that nature. The fastest way is where the parties has not chosen a institution, and where an intervention is required. In most of the cases, very easily, with a little intelligence, it can be given to a IA and an arbitrator can be appointed. So this is what I see in most of the cases. When people go before the court only asks, what is the dispute? If there is no dispute, so the disputed matters can be taken care of, rest of all the matters, an IA needs to be used for the purposes of appointment. This will take care of the biases as well. Of course, that the algorithm which has been built needs to be fair. If that scrutiny of the process of that algorithm is taken care of and the integrity is maintained for all the states, union territories of this country, you need not approach any court. If there is some dispute with respect to the appointment to IA, you can go to the court. It will make the entire system transparent. It will take care of all the biases, and it will be very quicker, easier, faster. And if there are cases which needs to be, so it will happen. That is fine.
I have only one intervention to make. Naresh, let me say
yes, absolutely.
What Manish says is absolutely correct. Now, let's say 99 cases, there is no difficulty. The IA throws out the name, everybody is happy. If there is a dispute, then even then the court should not go into anything other than what is your objection to him or her. What is your objection to this X being an arbitrator? Is he? What are your objections? That he is known to be a corrupt man, that he does not understand anything, his IQ is very low. What is your objection? An ordinary person with ordinary IQ with a little smattering of law should be able to do it efficiently. We go into this whether it should be done, and 20 pages judgment which goes into appeals, and then the second appeals and Supreme Court 136 and curative petition, and the law gets built up. The structure of the law is built, but this classic case of the operation being eminently successful and the patient dying on the bed.
See, I have one more reason why are Section 11 petitions so very vehemently contested. There is also one more reason, and it's a logic which I have also seen people doing so. I have also suffered, I've been the beneficiary and the sufferer on both ends insofar as domestic arbitration is concerned. The problem is that there is nothing in the entire mechanism in the Arbitration Act, and institutions, I can still see that they have a oversight over the entire proceedings. The difficulty is that the arbitrator does not want to decide the preliminary question, no matter how easy tattle on the face of it would be. Before the evidence is laid before him, entire period of 1 year plus 6 months and now 18 months have elapsed and full fee has been paid. The preliminary issue is decided for the first instance, and that 18 months is something which you are, or 12 months, 16 months, you need to suffer. So therefore, there has to be a mechanism that not more than 50% of the fee would be payable, where a Section 16 application needs to be decided. And if the evidence is required, that be led insofar as that application is concerned. Practically, this is what I have seen happens day in and day out, not with respect to, I'm not, whether you appoint a retired judge or a advocate or somebody else, this menace needs to be statutorily looked into, and half of it would be then, Justice Shri Krishna started off with that, some rules may be framed. In those rules, something of this nature, insofar as the preliminary issues need not be decided finally at the time of award. This is what most of the arbitrators have seen. Why decide the matter unless we have heard the parties to full, and the full fee has been paid? That is a huge big problem. So if at all it has to be made an administrative decision and an appointment needs to take place, some guidelines and some mechanism needs to be put in place where this preliminary objections are decided as preliminary objections, and in the GAB not stated that it can only be, it's a mixed question of fact and law, and it can be decided after the full evidence is led. That's the suggestion which I have.
So two related questions, and I think, sir, this is a very, very interesting thing which has come out of this discussion. And sir, I would want to, let me take, sir, what Manish has said, what Manish ended with, and ask a question around that first, and then, sir, I'll come to the other thing. The first question is that when Manish is speaking about getting the preliminary question decided. Now, I have a matter, sir, in which truly I'm struggling, because on the preliminary question, I know there is a recalcitrant party which has filed a Section 16 application saying that the tribunal does not have jurisdiction. It is on the face of it something which I am fighting against. The tribunal decided that issue as well. And today, unfortunately, that has gone in a 227 to the High Court. Now, the High Court, sir, unfortunately has granted a stay. So, sir, it's and this is where the problem to my mind lies. So I don't think statutorily mandating a preliminary question to be decided at the very first instance is the answer, because, and I'm sure Nick will educate us on this, because internationally as well, there is nothing in no law. Is there anything which will say that a preliminary question ought to be decided at the very first instance? And so to my mind, the legislature kept it open to be decided by the tribunal at any given point in time. And more so particularly at the end of when they are deciding, when they are giving the final award, is so that there is a final challenge and there are no challenges in between. That to my mind was the answer. But so therefore, what really is the answer to what Manish is saying?
Naresh, that is why the law has been so carefully tailored that if the tribunal holds that it has jurisdiction, that is not made appealable at all. You have to continue with it and render the award, and your decision whether the jurisdiction and issue is rightly or wrongly decided will be only appealable at the end. Absolutely. But if the tribunal says I have no jurisdiction, then the award is terminated. I mean, the award is made, it's a termination award. Then that is made appealable. That seems to be, you see, this is the thing. Let me again confess, this is something that happens regularly when you have civil suits. When jurisdictional issues get decided, they get carried to the first appeal, second appeal, and 136. When the merits lie in cold storage for 25 years. This is the reason why the arbitration mechanism avoided all this. And so whatever your problem, raise it under Section 16. If you have jurisdiction, he will say, I have jurisdiction. And carry on with it. If he says, I have no jurisdiction, matter ends, then you appeal, do what you like.
Correct. So the related question, sorry, the other question that I wanted to ask you, sir, was again some of the discussion that we just had. So we hear this very often, and we are told very often that why is the court not interfering when it's a matter which on the face of it requires interference? So let me just give an example. Let's say a person says that I don't want to appoint an arbitrator, And the simple reason is because my signature is forged.
Yes.
And a Section 11 in this situation is filed. Now, if the court was not to interfere in such a situation, then you'll hear criticism saying that something which is so on the face of it obvious that the person is saying and on oath, he's signing the petition. It is supposed to be on oath before the Supreme Court. And yet you come to a situation where an entire trial has to run for 18 months and monies have to be spent. Don't you think, sir, in such a situation?
That is a simple thing. If somebody comes to me and says this is the arbitration agreement and you are the party, let us say instead of saying Naresh Thakkar, it says Manish Lamba. It's obvious to me that it is not signed by you. No, but by no stretch of imagination can you say that your signature reads as Manish Lamba or Sri Krishna. You can't say that. So that is prima facie. But if somebody were to say, hey, this is not my signature, although it purports to be my signature, it's a forged one, or that it has been obtained under coercion, or that it is obtained under administrating some drug to me. Now, how do I decide it at prima facie stage? I cannot decide it unless I record evidence. If it's a question of forgery, then I have to record evidence of an handwriting expert. Now, if you start doing that, then what happens to arbitration? Arbitration takes a back seat. Therefore, the right test is all that. Forget all this vigorous and summary and all that. Forget all that. Look at it. If it tells you that it is his signature, doesn't matter. Give him the benefit of doubt. Say, go ahead and let it be taken up for jurisdiction. Let him record evidence and say this is his signature or not. This is the whole theory of competence. Otherwise, what is competence? If at every stage you have to run to the court and the court has to decide as if it's a suit. So what are we achieving by this?
So, Nick, let me come to you and ask you the same question that, you had this same problem which arises in England. A person comes and says that my signature is forged. Parties make an application to the court there. How would the court deal with it? Now, how would the English court deal with this? Would they go into the questions of arguable case? Would they go into the questions of facts? How truly would this be decided in an English court?
Sure. Thanks, Naresh. And thanks for involving me in a very interesting discussion. I do think this is vital. It's not a side issue. If you can't get this arbitration process started, then it's of no use to the parties and it's of no function to society. So I think Section 11 and the debate you're having here is absolutely crucial. I think it applies both whether you're dealing with institutional arbitration or ad hoc arbitration. I have long been banging the drum for increasing institutional arbitration within India and delighted by the progress being made by MCIA, but it's not the only answer because there will always be a thriving ad hoc arbitration ecosystem in India, just as there is in London, just as there is in Hong Kong, also to an extent in Singapore. So you need to make the process work for all of them. We don't see this very much in London. We don't see it very much in Singapore either. I think there are a few reasons for that. One is obviously the prevalence of institutional arbitration, and you're only going to get into the court's interference in appointment of an arbitrator if you're in a situation where there's no other process to get that default appointment made. If a respondent just says there's no dispute, I'm not making my appointment, then where do you go? Now, obviously, if it's pure ad hoc, you might end up in India in Section 11. But a lot of the market in UK and in other jurisdictions in which I operate, you end up with either institutional arbitration or an appointment process that you can go to. So you don't have to go to the court. And indeed, if you go to the court will say, look, there is a process here for appointment that doesn't involve me, the judge, making that appointment. Go to the LCIA, go to the PTA, go to the ICC and get them to make that default appointment. And so most often in London, we don't get to the court on these situations. There is certainly a power. There's an equivalent to Section 11. Section 18 of the UK Arbitration Act allows the court to make an appointment where the party's appointment procedure has failed for any reason. And it has a flexible range of options. It can give directions to make appointments. It can constitute the tribunal from appointments already made. It can revoke appointments, or it can make its own appointments. When it does so, and I think this is the crux of your question, it does not get into the merits of the dispute. It's only asking whether there is a prima facie basis to pass this on to the tribunal. And the test that has been reiterated under case law is the judge says to him or herself, is there a good arguable case here that a tribunal would have jurisdiction over this issue. And if the issue is there a contract with my signature on it, then that's the issue. Someone's got to decide that. If there's a dispute on it, it's got to either go to a court or it's going to arbitration. And it goes to arbitration if there's a prima facie argument there that a tribunal should have jurisdiction because that's what the parties have agreed. If there's a good arguable case, the parties have agreed to send it to arbitration, then at that point, the court says, that's as far as I go. Off you go to arbitration, the tribunal has jurisdiction. As Justice Sri Krishna said, that you then get into competence. That's the whole essence of the arbitration framework. That tribunal should be able to decide its own jurisdiction, but the court should have minimal touch points with it. Its judges to just, its role is to get this process moving as quickly as possible.
So Nick,
the whole idea is, one second, the whole idea is there is an arbitration process available. The parties apparently have signed an agreement, but they are sparring over it. All that the judge has to do is pick them up and throw them into the arbitrator's lap and say, you go and decide whatever you want. But if the judge says, no, I'm going to carry the ball, then the matter ends there.
So I do have again a related question to what you are saying, sir. But before that, can I just stay with Nick for a moment and ask Nick a question? Nick, what you spoke of, and absolutely, I have no difficulty. So what you are saying is that the judge would usually say that, you know, your other institutions, go to the institution and get this, you know, appointment done, and they would not get into, you know, such issues. Now, I do remember, you know, and I use this decision of the English courts in Philly shipping in one of my current matters, where, you know, one of the questions was it hinged on forgery, and there again the court actually you know, went on to say that we are not going to interfere, and we are not going to interfere in the appointment of the arbitrator. We would rather let the arbitration proceed. Now, would you have any? Has the law changed in England, or you know, Fiona Trust and Philly shipping remains the touchstone on which arbitrator appointments even today are done?
Yeah, look, that Fiona Trust, you know, rhetoric of the court will support the party's choice of arbitration as a one-stop shop. It remains the sort of the theme of courts' handling of arbitration matters, and at all points the court is there to try and resist the urge to get involved. You know, one party will always be urging, you know, a court to get involved, especially if there's a potential to delay and create an appellate route that's going to slow things down. And the court's role is just to try and resist that. You know, judges are human. If they see a problem that needs solving with a judicial hat on, he or she is going to want to try and get involved and do justice between the parties and make a decision. But no, the approach of the English court remains, try and keep your hands off it as much as you can. The more recent seminal case on arbitral appointment was a case called Silver Dry Bulk and Homer Hulbert, where a court was invited to confirm an appointment. And there you had a situation where one party had started an arbitration, made an appointment, the other side hadn't responded. In fact, they were insolvent, and it was rather unique facts that it was continuing at all. But the procedure then allowed that first appointee to become a sole arbitrator and the process to go forward. And that claimant then went to court and said, look, will you confirm we've done this right? Because we don't want, you know, later on there to be a challenge over this appointment. And the court said, no, that's not my role here. My role is not to confirm appointments. My role is really hands off. If the party's chosen procedure has worked and got your tribunal in place, it's not for me, the court, to confirm that that appointment is properly made and that tribunal has jurisdiction. That's for that tribunal itself. Now, of course, at the end of the day, an award could be challenged or enforcement could be challenged on the basis of jurisdiction, but that's for another day. That shouldn't be slowing down the process of getting the arbitration up and running and that tribunal appointed.
I would say at section 11, the default is don't do anything, ask them to go to arbitration. Exceptionally, maybe 1 in 100 or 0.1 in 100. Interfere if you think that it's absolutely necessary. The only problem is the judge interferes, then there's a whole course of appellate jurisdiction going all the way, at least in India, to Supreme Court, and then also to Supreme Court, like curative petitions and things like that. People just get bogged down by that.
So, A interesting point that Nick made was obviously about the English courts keeping their hands off and asking the parties to go to the institutions to get the appointment done. And so we all know that you've always advocated about institutional arbitration being the way forward. In fact, that is the thrust of the 2019 suggested amendments by you, sir, by the committee headed by you. And so, in fact, we all understand that Indians continue to be the largest users of institutional arbitration abroad.
That's right, except in India.
Except in India. And that's the point, sir, except in India. Because just the other day, Singapore announced, SIAC announced that the largest number of caseload that they have today in this year as well, the year gone by, is Indians. And so you truly need to see the disparity of the users from where India is and who's the next best. I think there is a difference of almost 30-40%, if not more. Now the question, sir, is that certainly in India there is no lack of institutions. We have MCIA. It's a primary institute. So it's a premium institute, if I may say so. So it's today the rules are second to none. We have an excellent registry. Then, sir, what truly is required to change the scene in India? Why is it that we yet continue to remain in this ad hoc mode? Is it because everything is sir, looked at from a judicial perspective, or so because cost-wise, again, I personally, if one was to ask me, a client was to ask me, I'll say that there is, in terms of cost also, in an ad hoc arbitration, you may end up with a larger and a higher cost than if it was institution-driven. But yet I see the resistance from the client, and so the resistance is not little. I mean, it's quite a lot. So what, according to you, sir, requires to change this scene?
Basically, two things are there. Why does anybody want to go to, let's say, two Indian parties also would love to go and have the arbitration done in Singapore? Because of these reasons. These reasons is A, the institutional monitoring on that. And B, the courts are most reluctant to interfere at any stage. And even after the award is made, the court will not interfere unless there is an absolutely good case. Now, I have known awards which in India would have been admitted for the asking. But Singapore court, I remember in one matter, one party did not turn up on time. We waited for 2 hours, he didn't, we held it ex parte. Now in India, a judge like me would have said, "Hey, Evans would not have fallen if you had allowed him one more adjournment." But in Singapore, they just threw him out on the air and say, "You were given a time, you did not appear. Sorry, we will not appear. You'll have to suffer this." Now, if that attitude is there in the court of this country, all good people will certainly do it. No, we don't do it. We amend the civil procedure code. But tell me honestly, has the amendment really worked in practice? Have all the written statements been filed on time? And if not filed, are they held ex parte?
They are not. And that's the truth.
Adjournments are still granted on, the ingenuity of Indian lawyers is trying to find out a good reason for adjournment.
Absolutely, sir.
No, this is the whole problem. So these are the reasons why people say it's better that we'll go either to England or to Singapore or to Hong Kong or to wherever else, Switzerland, and take our chance there. Because at least the judge will know, the judge will not interfere unless it is absolutely necessary. And even when he interferes, the matter will be over very fast. See, the problem with interference here is, if a petition is admitted today, God knows when it will come up for hearing. First of all, when will it come for admission is itself a $1 million question.
True.
I think that's a very valid point. I think the downsides to going to court in India are not very high. If you're the respondent and you can punt something off into Section 11, that's 12, 18 months where the arbitration you're resisting isn't able to start. I think in other jurisdictions, there can be a much higher downside. A, the decisions might get decided quicker. I'm not saying, other court jurisdictions are so much quicker, but certainly things like costs. If you go into the London court, Singapore court, Hong Kong court with an unmeritorious application on an arbitration matter, you'll get thrown out with a degree of prejudice and a costs award against you. And those can be substantial and meaningful costs, and that can be a big deterrent. So I think cost is a point here. And also, I think the ability to appeal. I think in many jurisdictions, and I mentioned the English power under Section 18 of our Arbitration Act, in theory, it's appealable. You need leave of the court to appeal a decision under Section 18. In practice, that just doesn't happen. The appellate courts aren't interested in hearing, fact-specific appointment questions. And I think if you don't have that appeal route, then obviously the potential delay gets cut down dramatically. So I think, cost disincentives and the idea that you don't get to appeal once, twice up to the Supreme Court, make this whole thing delay for months and years, would have a dramatic effect on the willingness of respondents to make these kind of applications.
And ultimately, if the respondent knows that if he fails, he is going to run up a bill of cost which he will never be able to meet. That is the biggest terrorism that he has.
True.
Whereas here the judge will say, I am going to impose cost of 2,000 rupees on it, which is less than a flea bite.
So a very interesting question from someone in the audience, and let me put this across. I think this is a question, sir, that I should put across to you.
Yeah.
And the question is this, that in case of an international arbitration wherein the tribunal is to be constituted of 3 arbitrators, if the presiding arbitrator is a retired judge of the home state of one of the parties, appointed unilaterally by such party, would it not be justifiable ground to remove such a presiding arbitrator on the basis of perceived bias? And I think, sir, let us have 2 views on this topic, sir.
Naresh,
Yes.
the rules make it clear, no? Usually I've come across the rules which will say that the presiding arbitrator shall not be a citizen or a resident of the country in which one of the disputes is arisen. Now, supposing, let's say there's a dispute between an Indian company and a Swiss company. The presiding arbitrator can neither be an Indian citizen nor a Swiss citizen. These are the normal rules that we follow. In fact, the rules are there. In SISA rules provide for that. ICC rules provide for that, if I remember rightly. This question is not something which can be determined ad hoc. If it's an institutional one. Now, if it's an ad hoc one, then you don't agree to it, that's all. Because if it is ad hoc, the presiding officer is the result of 2 persons agreeing. Your own nominee and his nominee. Why did you agree to it?
So, sir, now in this situation, if a Section 11 comes to the court, sir, what happens?
Well, how would Section 11 come into the court? Tell me.
Sir, because in an ad hoc arbitration, assuming for a moment it's an India-seated arbitration,
Yes.
and sir, one person was to not appoint the arbitrator, then, sir, would this a Section 11 was to be filed, and
Yes.
then an argument is raised in the Section 11 court to say that the reason why I have not appointed any arbitrator as of now, because I find that the arbitrator appointed on the panel is an arbitrator of the same jurisdiction, and I do believe that there is a perceived bias. How would the court in this situation, sir, deal with such a Section 11, sir?
Look, I am not willing to buy the argument that if I am an arbitrator in an Indian dispute, I'm loyal, I'm 100% going to be biased in their favor, nothing of the sort.
Yes, that is, sir, absolutely.
In fact, right from white industry till today, you will find that wherever I have said no, I have said no, that's all. The point is this, assuming there is some substance in what you say, then the institution can change it. Why do you have to go to we are talking of an institutional arbitration, isn't it?
Yes, sir.
So the institution can say, all right, my rules provide for different jurisdictions. I have arbitrators in different jurisdictions, so I will not agree to it. And assuming it goes to a judge, the judge can also say this. I say, let's be fair. There is a perceived, after all, what is bias? Bias is not factually proved. Bias is your perception of what is going to happen. But if you feel that you are going to not get justice, you are entitled. Sometimes we tell the judges also, no, that you should recuse yourself.
Naresh, I do not recall the outcome, but in an Indian arbitration, a Pakistan High Court judge was appointed.
Yeah, possible. Why should the Pakistan judge be bad? He's good. As long as he's honest, he's good.
Absolutely. So, Manish, let me turn to you, and let me put a hypothetical scenario to you, and let's see, how this turns out. Now, your first choice of an arbitrator, nominee arbitrator in your matter, actually, let's say, is a construction law specialist with a technical background. Now, your lawyer was to inform you that the opposite party has nominated a retired Supreme Court judge as one of the arbitrators.
Actually, Manish will get a walkover in such a case. I can assure you, Manish will get, unless it was me, I am telling you. I have done a lot of construction things and people are worried, how the hell do you know so much of construction? Because I said, I am a science graduate, I understand technology much better than all of you put together. No, you're right. Then the choice is, look, if the arbitration agreement requires an engineer, then no matter whether he is a Supreme Court judge or not, he is not qualified.
Yes.
If the arbitration agreement is silent, then it's your choice. You can have your driver as an arbitrator. Who prevents you? Why do you want a Supreme Court judge?
Absolutely, absolutely. And so that's the reason my question to Manish is that everything is open. Your agreement does not require you to have a technocrat. Your agreement is silent on who you can appoint as your arbitrator. Now you have, in your wisdom, you are the GC. You have now decided that your arbitrator ought to be a technocrat and with someone with a specialist knowledge of construction. But now your lawyer comes to you. I am your lawyer. I come to you and I tell you, look, but the other side has appointed a Supreme Court, retired Supreme Court judge. And I know you and I have had this discussion many times over on our interaction. But I want you to put your hand on your heart and tell me here that what would you do in such a situation? Would you go ahead with the nominee, or will there be a change of heart? Again, I'm not saying it will be because you want it. Let me put it this way, that there is pressure from your management, and your management now tells you, the promoters of the company now tell you, oh, but you have a retired Supreme Court judge on the other side. Why don't you find a CJI who can be our nominee? And then both of them get together and appoint someone who was there senior. Would you want that, or would you yet continue with your appointment?
See, Naresh, if I were to give you an honest answer, unlike you, I have only one client. That's my management. So it's very difficult to go against unless you have very good reasons. So therefore, what happens is that the law firms, arguing counsels, the entire fraternity, and ultimately, I am also not as independent as I seem to be. I am also
That's right.
of this entire system. But let us take, for instance, if there is, I know for a fact, I am not sure, it's your firm only appointed expert instead of a lawyer, instead of a judge. So we get the market news. So the point is that if the matter is absolutely hyper technical, then if I were to give an independent choice and I was not to go back to my promoters and they were to trust my wisdom, if I have to go back to them, I will go by their advice. But if they were to trust my wisdom, and if it is a hyper technical matter, I would not go for a retired judge.
Absolutely correct. I mean, that makes sense.
But if at all the law firm has an influence on the promoters, if there are certain people that why did you take this kind of a chance, if there are those kind of doubts which are there, which should not ordinarily be there, then certainly to err on the side of caution. And as I told you that I have only one client, unlike you who can experiment with many clients, it will be very difficult for me to take a chance.
Yeah, ultimately,
This question is put to the door of many of the GCs. Many of the GCs complain that why are always retired judges appointed? And you are the ones who are to be blamed. You are the ones who nominate. I wholeheartedly take that blame. But in many of the cases, it's the system manner in which it works. It is changing. It is certainly changing. And this choice was available to me at the time of drafting of the contract. I could have written it over there that in case of a dispute, the matter will go to a person who is a civil engineer. Now, there are difficulties insofar as the Indian legal system is concerned, as Justice Shri Krishna has said that the petition was not submitted within 30 days, or reply was not submitted within the stipulated time, and therefore ex parte proceedings and things of that nature. Those all difficulties are there with those technical judges, the technical arbitrators. That apart, if I want to make that bold choice, and if I have to take my management into confidence, and when the parties are at the negotiating table, it is at that time that we need to deal with these clauses. And the time has come that we will move from boilerplate clauses. We haven't done that, but I'm sure the industry is maturing, and when they will find wisdom insofar as lease disputes are concerned, insofar as your construction disputes are concerned, insofar as your engineering disputes are concerned, or several such nature disputes are concerned, when the legal industry, the in-house counsels, the law firms will mature, this thing will come out. The day that happens, lawyers will be out of job. the business will take care of it.
See, Manish, the situation can be solved. You can always have a clause saying that this will be arbitrated only by a technical person of this qualification. Now, both persons will be technical, right? Or three persons will be technical. Now, the difficulty arises is because they are not familiar with legal rules, they must slip up somewhere. The right thing to do is agree for an appointment of a tribunal's clerk or associate who will be a technically qualified person. Now, if I were to say somebody who has got this stipulation and worked for so many years only can be appointed, that man will tell you that this is wrong, sir, you can't do this. And he will advise the person. His job will be to advise them. Ultimately, the decision will be tribunal. But at least at all given times, he will have a many bit of good legal advice.
But if you look at traditionally how arbitration used to be, arbitration in the mercantile markets, in merchants, in other things, they were all done by their own peers.
Stock market arbitration in 3 minutes, 3 days, 3 months it is over. And
Yeah, GAFTA.
over there.
All these, insofar as the mandis, the cloth traders, everybody used to.
Diamond traders, they used to have their. Now, if you go abroad,
over a period of time, what we lost is that both common sense and impeccable integrity. If all that what was required and both
law, legal
nothing was required. But that
Can I
we have actually departed from common sense, and that is why I would said that by a slip of a tongue I had said IA, because lawyers understand IA more than artificial intelligence.
Yeah, correct.
Sorry.
Just wanted to correct that also. And therefore, the time has come when at many places we are not even applying common sense, and now we are talking about finding a solution through artificial intelligence. So therefore, insofar as when these contracts are drafted, these large law firms sit across the table, or where the business community sits together. Today, we do not have the buy-in of the business community. GC's buy-in we have buy-in of the lawyers and this entire community, and it has become, I think arbitration and justice are too serious affairs to be left to the wisdom of lawyers alone.
Yes.
Okay.
Retired
I
or sitting or
hear
law
you.
firms.
Manish, we hear you. Let me, out of what you are saying, there is an important issue which arises. And so we've just heard Manish up on various issues, but one of the first issues that we heard him on was, sir, his argument, if I may say it again loosely, on appointment of judges, retired judges as arbitrators. Whether it is promoter driven, whether it is the requirement because a lawyer tells you to do so, and whatnot. Now, sir, and this is often a whisper in the corridors, but rarely in an open forum is this question ever raised. But let me, sir, now ask this question of you, sir. Appointment of retired judges as arbitrators, is this a boon or a bane?
Depends on how you look at it. Supposing it really involved an intricate question of law, it will be a boon. Rest of the time, it would be a bane, because when we bring in unnecessary legalities, you make it formalized so much that everybody, including the judges, get confused. So I wouldn't say it's a simple answer, but there are issues which sometimes are complicated, which need a little care. And forget all that. Ultimately, whether he is a judge or not, the arbitrator should have a fair understanding of the legal process. Otherwise, he'll make a mistake and somebody in the appellate court will say, oh, this was not done. And check a simple thing. He is not allowed to argue. I mean, the rules normally say that each side will be allowed to argue the same number of hours that the other side is being given. Somebody argues for 10 hours, I give him another fellow 3 hours and say, I'm satisfied, I don't want to hear you. Elementary mistake. Now, this doesn't require too much of law, but it requires at least this common sense that you should treat them fairly. Now somebody says, you have given me 10 days for filing a reply. He says, yeah, I'll give you only 2 days for reply. Then obviously it is wrong. These are the areas where a lawyer or a judge will be able to look at it objectively, because he is not influenced by the party's thinking. Now, but if he is influenced by the party's thinking, then he is a bad arbitrator.
So, Nick, now this is not unheard of English courts as well, or rather it's not unheard of in England, may not be as common as it happens in India, but still retired judges do get appointed as arbitrators.
I've sat with some.
Absolutely, sir. Absolutely. So it is not unheard. It is just in India that we have now got, it has become a fashion to disparage a retired judge at every point in time in an arbitration, to say that, why should it be constituted of a panel of retired judges? Why should we have only a panel of retired judges? In fact, sir, even I've had in one instance a retired judge from the House of Lords.
Yes,
As
I've dealt with House of Lord judges.
Absolutely. Now, sir, and sorry to nick this question, what do you think is different then between what transpires in India vis-a-vis what happens in England? Do you see a qualitative difference when, let's say, you have retired judges sitting in England vis-a-vis retired judges, a panel of retired judges sitting in an arbitration in India? And I'm sure with your experience in both the jurisdictions, you've done enough work in both jurisdictions. Can you tell us, what is the qualitative difference that you've seen in a panel of retired judges where you arbitrated in India and when you arbitrated in England?
Yeah, look, absolutely. Retired judges take a lot of appointments in England. There's nothing fundamentally wrong with that. A good lawyer is a good lawyer, and often judges do bring an excellent, brilliant legal mind and a real judicial mindset to make decisions. I think what often we see in the London market in particular is it's competitive. Retired judges come from the bench and make themselves available for arbitral appointments. Some quickly get taken up and get very busy, others less so. And often the difference is not about the quality of the legal mind, which if you've come out of an appellate court in either the UK or India is going to be pretty high. It's about whether you adapt yourself to the arbitral process, whether you think you're still in court, or whether what you say is, I'm now doing a different job. It's the parties process. I'll be guided by the LCIA, the ICC, the tribunal chair. And often, a good piece of wisdom is that, if you're straight out of the Supreme Court, you don't go in the chair. I know often it's very hard for the parties to resist putting the most senior person in charge of the procedure, but actually you want the most experienced arbitration practitioner in charge of the procedure. Put the brilliant retired appellate judge on the wing and give them a chance to see how arbitration is different to court litigation. And I've had tribunals where we've had retired English Supreme Court judges alongside retired Indian Supreme Court judges. There's no inherent difference there. It's all about how you make the arbitration process work.
So one of the panelists has asked this question. Let me, put it across to Nick. If an order was to be passed by an arbitral institution, I don't know what it means, what the querist means when she says that, if an order is passed by an arbitral institution. But I take it that I think what she wants to say is that if an appointment was to be done by an arbitral institution, would that be subject to challenge? And will that therefore prolong the process of appointment of a tribunal, and would therefore that take that much more longer?
Yeah, well, it shouldn't do, because if so, for example, you have an LCIA clause, default appointment, a party fails to appoint, LCIA makes that appointment, then you get that tribunal in place. There's no scope for the English court in this scenario to hop in and say, let's investigate that appointment, because as I've just said, the whole point of the English court's powers stop at, is there a good arguable case that a tribunal has been constituted and should hear that dispute. Of course, at the end of the day, there can be a challenge on jurisdiction under Section 67 in the English scenario. So if the tribunal has not been constituted according to the parties' arbitration agreement, or if it's exceeded its jurisdiction in some way, that award can be susceptible to challenge. And, a party always has that right at the end of the process. But in the meantime, it doesn't get to invoke the courts and involve the courts in questioning whether that LCI appointment has been properly made, because so long as it crosses that threshold, very low threshold test, that tribunal should carry on and decide its own jurisdiction, including the issue of whether it's been properly constituted.
Thanks so much, Nick. I think we've come almost to the end of our time. Shreya, can you tell us if we have one more, if we can take one more question?
Yes, we've come to the end of our time, but I think we can close with one last question.
Okay. So Nick, I'll let you have the final word on this subject. Is there a lesson that you can offer from either London or Singapore, for Section 11 situation in India, and what do you think needs to change to reduce the Section 11 problems and dealings?
Yeah, well, look, it's about judicial attitude, and we have a judge on this panel who has shown an admirable attitude to steer clear of this and keep their hands off. So I think hands off is one point. The legislation doesn't require the court to get hands on. I think, as I said, maybe a greater use of adverse costs, maybe a greater deterrent from the courts. And fundamentally, I question, I know it's a difficult one, but the appellate rights, the ability to take these cases on appeal and on appeal again, I think is problematic because it just generates so much delay. And maybe, some of the Indian system need to look again at whether such extensive rights of appeal should be allowed on these kinds of decisions.
So thank you so much, Nick, and thank you to my esteemed panelists for sharing their views on this panel today. With this, we have unfortunately come to the very end of time for this session. I hope all of you enjoyed this discussion and will take home little bites of the issues within this discussion and within this not so innocuous provision to chew on. We have heard our panelists, and I personally have always believed that, one last thing that I would put across is that we've always spoken about this appointment of judges as arbitrators. And I said that we say it in a very disparaging manner. To my mind, it is wrong, because it is not the appointment of retired judges which is the problem. I think it's the choice that you make as the party, because if you make a wrong choice, then it's truly horses for courses. And if you made a wrong choice, then you suffer the consequence of the tribunal that you have. If you made the right choice nonetheless, and even if it means that you have 3 retired judges on the panel, your arbitration can run absolutely smoothly. And I can tell you today, arbitrations are running their course even within 12-month period, as what is mandated within the law in India. And they are running very, very smoothly, and things are happening. So it truly needs a change of mind from all stakeholders, and we just cannot continue to disparage judges on this. I think as parties, as lawyers, and as judges, all the stakeholders need to come together, and they need to improve this system of arbitration rather than all the time wanting and hankering for a change of law. Because you may continue to ask for change in law, legislature may continue to change the law and tinker with it. The more they tinker with it, the more us lawyers will find problem with the law, and the more we will see to it that the matter goes to court. So with that, let me thank you all for being such a patient audience, and until next time, thank you.
Thank you, Naresh. Thank you.
Thank you, everyone. Before we sign off, we have 3 more sessions scheduled for today at 2 p.m., 4:30 p.m. and 6 p.m. The details of these events are available on the MCI LinkedIn page. We hope that you can join us for those events as well. Thank you.